Lordship are hearing the matter.
Can we say about 1 hour or
About an hour. I'll finish. I'm finish in 1 hour.
So I'll come at 1 hour. I've been waiting for my turn for the last 3 days.
Your choice.
And for a matter where the issue is only whether notice should be issued or not.
And I think we are past that stage.
I'm sorry, we haven't passed that stage. The stage is that the court said they will hear me.
Raising his voice won't help us. So you lordship to decide.
I'm not raising my voice. I'm saying it was made clear that the lordship,
voice.
yes, and the lordship will decide whether notice is issued or not. That is how it started, and that's how I want
Friend
to.
appears for a caveat, and he's worried about whether notice will go.
I'm not worried. I'm saying it should not go.
okay?
This is a gross case. But I will address your lordship in my turn.
File caveat
Yes, on behalf of the state, there are 2 respondents.
under which provision?
There is a provision for file.
Just wanted, because I personally checked the Supreme Court rules and I didn't find any in criminal, SLP criminal, can you file caveat?
So there are orders, but I can show them. I'll bring it if necessary.
It's all technical, but just
I follow that.
for my
If necessary,
for clarity.
I'll show. I appear for one response.
Permit you to argue, no doubt about
Grateful,
it.
Lord, but I will also look at it. Your lordship has mentioned it.
We him notice probably if we allow you to argue.
Lord, I mean, that's a.
See,
I must say this. If surely after hearing this matter for so long, if your lordship feels it doesn't call for a notice, I'll sit down right now. But if your lordship feels it calls for consideration, I mean, if my friend is going to ask for an adjournment, then we might as well get nothing.
Will let us not preempt the courts of.
I am not asking for any adjournment.
Exactly.
I am saying it should be dismissed. That's what I will not endeavor to tell the court.
That's fine. But it can't be at the end of it, then you say, all right, then I'll file a reply. So then
No, counter affidavit is already filed.
not
No, it's not fine.
Oh.
If there is no notice, blood, how will there be a counter?
No, but what was that was before the.
That's before the High Court.
I only do not want to say, lordship has not asked me a question. I'm only saying, if at the end of 1 more hour, my friend is going to say, lordships have heard me fully, and a lordship feels requires consideration, then will he ask for an adjournment or will he go on? That's something a lordship will have to consider.
Will.
Yes.
I don't want to answer that. See what will happen.
These kind of things one shouldn't, I think they are far too serious rather than what else.
Was not originally conceived under Article 136. That is possible.
Neither will not is the
For
civil
notice for
procedure court.
interim relief.
No, it has evolved through practice.
Correct.
Will not neither in the civil procedure code is there a provision for notice. It has been evolved, not in the last 30, 40 years.
Has been
It has happened.
from evolution now reached
It has become
evolution.
it has become a law.
So you first hear a matter 3 days whether your lordship will issue notice, then you hear it for 6 days after you issue notice to grant leave,
What?
and then the appeal will ask for 2 words.
You can correct us if wrong. Initially, it was either granting leave or
Of course,
dismiss.
of course,
I think that's
with
how.
respect, yes, my lord. And then this notice process came because if an interim order is sought, only fair you hear the other side. Otherwise, I remember, in fact, back in the day, the rule, your lordship, but that's why I introduced the rule, saying if there is a counter in the High Court, please file it before us. So we want to know what the other side's case is, and then we decide. So ultimately, what is it? Your
So the
lordship,
entire record is with us, so
entire record is here.
no need to as such.
Exactly. And in a criminal case, where is the counter affidavit?
Lord, that's now the procedure of this court that a lordship grant. If we go back to the old days, then follow the full practice. That a lordship grant an ad interim order, grant leave. There is no need to hear the other side even for ad interim.
But normally we take into consideration only those documents which were already produced before the High Court.
Agreed. Things have changed over the years. People give documents across. All this is happening. So if you have a restatement of the law, then we should go back to that position. Where there is no counter affidavit, record of the court, all that is there.
May I have a start?
Yeah.
Start to finish 60 minutes. I have a lot for your lordship's assistance. Put my thoughts down in a piece of. Thanks. It's become 5 pages.
Just spacing.
But it looks big because the font is large and the spacing is large.
No, that's okay. That's
It's a relief on the eye.
good for us.
I've covered most of this ground. Section 17 I inserted relates to the procedure by which an inquiry or investigation into an offence is conducted. It is a procedural provision which does not carry the obligation or impair any rights of a citizen. provision would thus be retroactive in the sense it would apply in future in relation to all inquiries or investigations being conducted. Such provisions have loosely been characterized as retrospective. Strictly speaking, provisions that operate in the future but antecedent facts are in that sense not retrospective. In fact, Manoj, this is well settled. If you rely on, if a situation is on antecedent facts, the famous three-judge bench decision in DCM relied on the English principle of construction, where for the first time company deposit rules were brought in. And the argument was this can't be retrospective, it can only apply to deposits received hereafter. Justice D. Desai in this court took the view that no, it will apply to deposits hereafter, not to deposits received hereafter. So it is not retrospective. Merely because a law for its prospective operation relies on antecedent facts doesn't make it retrospective.
They all come from that colonial sugar.
Colonial sugar. Because the principle, as your lordships know, is this: it is not that an FIR already registered prior to 18 is invalidated. That would be retrospective. But if after today you commence or initiate any inquiry or investigation, this section will apply. So it is not retrospective. It is prospective.
By necessary corollary, probably a next question which would arise according to me, if you said that this is a procedural and would it confer any substantive right on the accused?
The right,
if not followed.
yes, the right, that's a very important point.
Then that Garikapati
Yes.
principle.
This court has held sanction provisions, although procedural in nature, are a protection available to the accused and have to be rigorously followed.
In which judgment?
Yes, I'll give those cases. In fact, in Tata, your lordships have allowed appeal saying sanction will not
Well,
be.
if you see in the context of section 19 and 19 4C.
Yes, your lordships have invalidated.
Yes, invalid.
Set aside convictions.
Yes.
Not the, in Tada, for example, a serious thing like Tada, one of my lords judges, the lordship has set aside the conviction. Then, and I was wanting to show, I'll be showing that judgment also because it deals with the other aspect. What if there are other offences which are not covered by a provision which requires sanction? Then what your lordships have held is, your lordships have held is that if the other allegations are ancillary in character, then everything goes. And if allegations are substantive in character, then they may remain, but the Tata goes. So approval, sanction has always been considered, absence of prior sanction has always been considered fatal to the inquiry. And all that is required is you go now, you get the governor's sanction, you register the FIR. It's not that, my lord, the accused gets a discharge or is acquitted or acquittal apply, nothing of the sort. It's a safeguard. You haven't crossed this. Up till now, whatever you've done is illegal. You go get the sanction and you register the FIR and you're back on track. It's not that the offences are eviscerated. So, substantive right, not in the sense that you get go, as they say, get out of jail free pass. That's not what happens. Only this inquiry comes to an end. Para 5 is conducted prior to insertion of the provision not stand invalidity. That would make it retrospective. In that sense, the provision retrospective. However, all inquiries, it should be in that sense, the provision is not retrospective. I'm sorry, there's a typo there. Maybe please, I'm so sorry. Please add. Provision is not retrospective. However, all inquiries or investigations commenced by a police officer after the insertion of 17A would be governed by the provision. The general principle of the said provision being retroactive can be displaced by express language. So, but these are only general rules of interpretation. Parliament could have limited the application of the provision to inquiries or investigations commenced in relation to offences committed after the insertion of the provision by adding the words hereafter after the words into any offence alleged to have been committed by a public servant. I made this point yesterday, just for convenience. I put all of them down in writing.